Hello, everyone. Welcome to another one-on-one on Talking Feds. Everyone has been waiting with bated breath for the oral argument in the immunity case that's going to be coming this Thursday. In the meantime, however, a case that we've heard much less about was argued last week, and it is portentous, I think you could say. Maybe will turn out even more so than the immunity case for the Trump prosecution on January 6th. So I was hoping to talk about that, and I have as good a person out there as they come. Mark Stern, who is the senior writer covering courts and the law for Slate magazine, is with us and has been thinking about the argument. And in fact, we talked about it some together after a TV hit in U.S. versus Jeffrey Fischer. So, Mark, thanks very much for being here.
Thank you so much for having me on.
Could you please set up just the basic issue on the statute, which is an obstruction count, the same one that applies to two of the charges in the January 6th case against Trump, and hundreds, I would say, of the offenders, the marauders, January 6th itself?
Yeah, so the latest count that the Solicitor General's office has given us is 350 prosecutions over January 6th have used this particular charge under a federal statute known as 1552C. I'll call it the obstruction statute, as you did. This was a law that was enacted after the Enron scandal, when some individuals at Enron had exploited loopholes to cover up their misdeeds. Congress came in, studied what they did, and said, we need stricter laws here on obstruction of investigations and obstructions of proceedings. And so they enacted this statute, which I'll read you the relevant provision. It makes it a federal offense for anyone to corruptly obstruct, influence, or impede any official proceeding or attempt to do so. And it says specifically that an official proceeding encompasses a list of things, including a proceeding before Congress. So January 6th happens. The Justice Department starts bringing charges. As I think listeners will probably know, some of those charges relatively minor, right? Misdemeanor charges, parading on Capitol grounds unlawfully. This is one of the bigger charges in a lot of those cases. About a quarter of all of the cases involve this charge, and it carries a maximum sentence of 20 years. Now, of course, with the sentencing guidelines, no one's going to get 20 years for the offense on January 6th, but it's still several years for even first-time offenders. It's a major...
Yeah, and I mean, even with the sentencing guidelines being voluntary or precatory, it's the biggest charge in terms of what Congress has provided. So even if a court departs downward, this would pack the punch for people convicted of it and other crimes.
Exactly right. And so it's a big deal. I mean, that's the big thing here is it's a big deal, which is why Joseph Fischer brought this appeal to the Supreme Court saying, I really think that this should not be applied to me, that this does not apply to individuals who tried to delay the electoral count on January 6th. He has some factual arguments that he wasn't trying to delay the count, but they're not relevant here. He says this is really a statute about destroying documents, because a different part of it that precedes the section I just read is all about destroying documents, making it impossible for documents to be preserved, trying to interfere, alter the legitimacy or validity of documents. So he says this is a law about documents.
And let me stop you, Mark, just because we get a little more nerdy on these one-on-ones.
Sure.
And the that previous section is connected with an all-important word otherwise. If you don't mind, read the two sections as they are in tandem in the code, if you happen to have them. Or just explain how they are. They're not simply, one's over here and one's down there, right? And this is going to matter for the Supreme Court argument.
Yes, that's exactly right. I really appreciate nerding out here because I think it's really important to understand the move that's being made with this otherwise. I don't think there's much to it, but obviously the Supreme Court does. So the statute says, first, whoever corruptly, M-1, alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability for use in an official proceeding.
All right, so we have an object, and pretty clearly a piece of paper.
Exactly.
You're Enron, you shred something when the investigation's going on. That's a heartland violation. Okay.
Yes. And then it says, or 2, otherwise obstructs, influences, or impedes any official proceeding or attempts to do so, shall be fined or imprisoned not more than 20 years or both.
All right, and this is really familiar to us, but let's pause this second and just say the two competing schools of thought about what the import of otherwise.
Yes. So for the Justice Department, the otherwise is just a pivot to other offenses within this statute. So the Justice Department says, look, Part 1 is about documents, we accept that. But then it says there's a pivot otherwise and lists, an additional slate of illegal conduct, obstructing, influencing, or impeding any official proceeding. And so the Justice Department views that almost as a standalone and says you can read them, you can read this as a unified whole because it's all about obstructing, like, broadly, various kinds of investigations and proceedings. But within it, you can draw out this obstruction of an official proceeding as a standalone offense. That's what the Justice Department says. That's what the DC Circuit has said, and that's what the individual here, the defendant, fights. And he argues, and I think several conservative justices at a minimum agree with him, that the otherwise does not delink these two, that the otherwise cannot be read as this kind of full pivot toward other offenses, that it really keeps these two things, the destruction of a document and obstruction of a proceeding, inherently linked, and that to be guilty under this offense, you sort of have to have done, I think, and you can tell me because I'm not sure if I'm getting this argument right, I don't want to straw man it, you have to be doing both or attempting to be doing both. There has to be some effort at document destruction involved in this crime in order for you to fall under the offense, basically.
Yeah, and so we'll get to that in a second. And on that basis, the district court judge, a Trump appointee, Judge Nichols, dismisses the indictment. Right. The Court of Appeals, Judge Pence, she of the famous Seal 6 hypothetical, says, this is easy. It's just plain meaning. Have you impeded an official proceeding? I think official proceeding is pretty clear, and we can set that one to the side. It's congressional proceeding, and if you're trying to keep Pence from doing his job come the appointed hour, you're impeding an official proceeding. And now we come to the Supreme Court.
And I just want to footnote that, though, by noting, yes, Judge Nichols on the district court in DC did say, no, otherwise is not a pivot. These two things have to be linked. But 15 different federal judges on that court have dealt with these charges, and 14 of them read it the way that the Justice Department does and the way that Judge Pan did. This was the one sort of dissenting voice on the district court. And then when this goes up to the DC Circuit, it's only Judge Katsas, also a Trump appointee, who says, oh, no, this is being stretched too far.
All right, so now we go to the court, and your time is kind of short. So, how did it seem? Was there indication that especially the conservative justices were enamored or very interested in this otherwise linkage? That so it still had to be something about a document. How did you kind of hear and handicap the argument from last week?
So I heard at least 3 conservative justices, I think Justice Thomas, Justice Alito, and Justice Gorsuch, really latch on to this idea that the word otherwise is a link, a kind of hinge that keeps these two things connected. That if there's not document destruction, then you really can't just pull out this obstructing an official proceeding charge. There has to be more to it. I think I heard Justice Brett Kavanaugh going along with that as well. And I think I heard Chief Justice Roberts too. Justice Barrett really plays her cards closer to her chest than the men in general, and so I struggle to say where she lands. But I think she was
let's go with her in a sense, because that might matter. But so the 5 did seem to be that way, and I'll just add, I'm sure you'll concur. It's the kind of statute, this sort of white collar statute and an intent requirement in it that the court has in the past been inclined to narrow. And part of the questioning, it's quite clear that the statutory hook that you're saying that the 3 most conservatives, Gorsuch, Alito, and Thomas embraced, and probably Kavanaugh and Roberts. But what you really also heard them say is, this is just kind of broad. Kavanaugh, do you really need this? Roberts, it sure could apply in a lot of places. Not exactly an argument that by its terms it doesn't, but more kind of a queasiness at, certain hypotheticals that they pummeled the SG with. Like, what about a sit-in? Or it had just been the day after the bridge incident. What about basic? They're worried about First Amendment protests that disturbs things, but permits them still to continue, something like that. But it's thematically of a piece with the kinds of cases the court has been at pains to either shoot Congress down or trim its wings in the past. Fair?
Absolutely. It's this collection of cases involving bribery charges of officials, right? Federal and state, vague sort of corruption laws. These statutes that, like you say, are usually either white collar or targeting political corruption, that are pretty broad, that seem to apply to a lot of conduct that the court feels iffy about, that might kind of shade into First Amendment activity. And in those cases, the court, across the board, in a lot of unanimous decisions, has been inclined to narrow those statutes and to say, we really think that there has to be what I think is probably more of an extra textual gloss when it all comes down to it, right? That there has to be something more that the courts apply, because otherwise this is either going to criminalize way too much conduct or maybe even raise First Amendment violations. Although I'll note, and this is something that Justice Barrett brought up, if a statute like this is ever used to punish First Amendment protected activity, you can raise a First Amendment challenge as applied to your case.
Yeah, I mean, it's easy this point. No, it won't do it, because when you apply it, or the prosecutors try to apply to First Amendment violation, there's a motion to dismiss that is granted. So the line, it exists and would be policed already. But let's cut to the chase. So if Fischer wins, he's got all of these 300. Most have minor charges. They don't completely get off scot-free, but his biggest charge goes away. And now let's cut to the focus that everyone has. As you read it, and I want to put Barrett to the side for now, but if the 5 of them do say what Katsas did in dissent or Nichols below, what of the Donald Trump charges in the January 6th case, both what happens to them and how and when it happens to them, if you've got that?
Yeah, so I think that 2 of the 4 charges in the indictment that Jack Smith brought in the January 6th case get tossed out. And that probably happens because immediately after this case comes down, if Fischer wins, Trump, presuming that the whole case isn't chucked on immunity, right? Trump files a motion saying, these charges are basically invalid under the Supreme Court's decision. And I think Judge Chutkan has no choice. Maybe even Jack Smith has to acknowledge and withdraw. You're the practical expert here and could tell me the exact procedure by which that occurs. But I think that 2 of those 4 have to fall, because one is actual obstruction of an official proceeding, and then one is conspiracy to to obstruct an official proceeding. So those two, I think, clearly do not fall under Judge Katz's interpretation of the statute, maybe not the Supreme Court's interpretation. And at that point, and I'd love to hear what you think, actually, I think Jack Smith has to come back and maybe he files superseding indictment. Maybe he tries to bring more charges to salvage this case. But if all that case is hinging on is conspiracy to, strip people of civil rights and defraud the United States, I think it's a much weaker prosecution.
So I think so too. And just to be clear, conspiracy about civil rights and defraud the United States, those are the two remaining counts, the first and fourth, the second being a conspiracy to obstruct, and the third being a substantive obstruction, basically trying to browbeat and intimidate Pence from doing his job. But it's not, well, and we'll get to Barrett in a second. But so I agree, it's hard to see those two counts surviving. Now, the penalties for the other two, unlike with Fischer, are still fairly strong, and it's been such a long process, and they're so concerned about time. But the oomph and jury kind of understanding and theory of the case really are deeply undermined, it seems to be. Both those other charges, I remember this back from when everyone was speculating what will the charges be, I think are more vaporous and not as clean thematically. So it'll be a real quandary because it takes time, a lot of time. One interesting kind of asterisk, though, if they're considering additional charges, one of them would be, if they thought they could make it, they stayed their hand before, insurrection. And if there's a conviction, it automatically would, even by the Supreme Court's recent holding in Trump v. Anderson, disqualify him from holding office. And of course, if they bring it before he's elected, and then then he's convicted of insurrection. Katie bar the door, man. What a classic mess. Okay,
that's
but
such
I
a
agree.
Good point.
Yeah, I agree though. So two are out, and the case itself, if not completely neutered, is really harmed in its overall thrust. All right, but one little asterisk here, which is a point that Barrett was making, which I was focused on a little, but I think you have it as well. Do you want me to
tee it up?
All right, let me tee it up. So she was saying, do you really have to destroy a document, or so long as it involves paper that you're kind of messing with, though messing with gets a little tricky under a statute that talks about impeding and obstructing. But what seemed to be interesting her was the notion that Fischer could still be convicted, and a narrowing construction that says this really has to be about documents, by saying the actual voter certificates, or even the envelope, the magic envelope that Pence opens in the discharge of his 12th Amendment duties. If you're trying, he's not trying to shred it, but if you're somehow trying to neuter it of its legal force, would be something like that, would a holding that says, that does the linkage with otherwise and says it still has to be about documents, would that make his conviction survive? And that she seemed alone on that, but if two members of the Supreme Court endorse that view, her and either Roberts or Kavanaugh, it becomes, I think, the deciding, well, we'll see what the other people would do with it, but it could potentially be the narrowest holding for the case. And in that instance, it seems to me whatever Fischer has done vis-a-vis the pieces of paper, either the elector certificates or the envelope that Pence is opening, surely Trump is guilty of a similar intent to undermine, nullify. It gets a little bit of a stretch for impede or obstruct under the Sarbanes-Oxley interpretation of Enron people sticking things in the shredder. Because, but you know, there's the Pence's envelope wouldn't have been changed, but there is this idea about trying to smuggle in things that say I'm the elector here when they're not. So in that sense, the true pieces of paper are almost as if they're destroyed. Anyway, it's something to do with that she seemed interested in, and that would, I think, salvage the 2 counts against Trump. Though for starters, it would be a whole, briefing and, a lot of time trying to make this theory stick in the Court of Appeals. But I'll say one more thing and then leave it to you, which is I do think that it would go to Chutkan in the first instance. And if she endorses the theory, there's no interlocutory appeal. They go forward on it with the, sort of Damocles, that subsequently on appeal, the a Supreme Court or the DC Circuit could say, no, you've misread the Supreme Court's new holding in the Fischer case. You shouldn't have done that, Judge Chutkan, and these 2 charges are out the window. Something like that. Okay, that's a whole lot of stuff to throw your way, Mark Stern, but I know you can handle it, so, have at it.
Yeah, so I agree that seemed to be a potential narrowing construction that Justice Barrett was sort of finding her way toward. It's something that I think Justice Ketanji Brown Jackson gestured toward as well, which made me think that maybe she was trying to sort of salvage something from Justice Barrett's questions. It can be sort of read into the statute. I don't know that it's the most natural reading of the statute, but, when it's talking about altering, destroying, mutilating, or concealing a record, document, or other object, it says, with the intent to impair the object's integrity or availability for use in an official proceeding. And what I think Barrett likes about it is that it keeps that official proceeding hook there, which is so important to this case. And we know that Congress was thinking about an official proceeding for Congress because it told us elsewhere in the statute. And you would just have to sort of, like you say, make this logical connection, connect one more dot, as it were, to say, well, either they were trying to smuggle in fake elector certificates or, and I'm not sure exactly how this would work, but maybe if, they were trying to attack Mike Pence, you could argue that they were trying to get their hands on the certificates that Pence had, that they were trying to obtain and destroy or undermine the integrity of the electoral vote.
Undermine the integrity of, right?
Yeah, that Pence had on him. And that would, I do think, probably preserve those counts in the Trump indictment. But I think it would make a whole mess of many other January 6th prosecutions. Right? Because what you're doing effectively, if you say that, is you're introducing another element of the crime that prosecutors now have to prove beyond a reasonable doubt, right? I mean, that has not been proved in the cases that are charged under the statute that go to a jury. All the jury is asked is, did we prove that the defendant, corruptly attempted to obstruct an official proceeding? If we introduce that, it becomes, did the defendant corruptly attempt to undermine or impair the integrity of a document's use in an official proceeding? So I think a lot of the prosecutions and some of the convictions under this statute are vulnerable to attack. I think that going forward, the Justice Department is less likely to whip out this charge. I think in this particular case and in others, there might be more of an effort to push this to a jury trial rather than to sort of work out a plea deal. And it becomes less fearsome of a charge in a plea deal because, it might start looking like a paper tiger to some defendants and their counsel. The Justice Department is bringing this. Right? Yeah, they're going to say, bring it on. The Justice Department is bringing this and saying, 20 years, you better work out a deal with us or we're going to go to trial and you're going to be in prison for a really long time. If the Supreme Court does what I think Barrett might be leaning toward here, then that becomes again sort of a paper tiger, and I think defendants say, okay, well let's work that out and see if the jury can wrap its head around this very complicated new theory of what this statute criminalizes. And that worries me a great deal. And it seems like a maximally sort of disruptive approach to figuring out what this law means. And for that reason, I'm less inclined to think that Barrett's ultimately going to seize upon it, because I think that Justice Barrett does not like jurisprudence of disruption. I think that she likes cleaner solutions than that. And that was the solution that, we should note, Judge Walker on the DC Circuit did not lean toward, right? So Judge Walker on the DC Circuit, he was troubled by the scope of this statute too, right? He said, this is really, really broad. I don't want to apply it to anybody, whoever, like, does a sit-in. But he latched onto the word corruptly and said, okay, well, if you're obstructing a proceeding in exchange for a benefit, then you fall into this statute. I thought that was going to be where the action was at the Supreme Court. Turns out none of the justices really cared about that. They were interested in some of these other theories. But at the end of the day, I think Barrett just sort of has to find it within herself to go one way or the other on this. I don't think that she wants to introduce this novel theory that wasn't really briefed, I think, by either party, and put it forward, inject it into these already very complex prosecutions, and leave a lot of defendants and attorneys at the capital siege section scratching their heads saying, how are we to make heads or tails of this?
These are all really great points. I'll just add a couple things. At oral argument, Jackson, Sotomayor, and Kagan seem to be very much on the Florence Pan line of, this is straightforward and easy. The words just say it clearly. So it would be a kind of a funny alliance, and they would need a fifth. That's one point. The other is, no matter what, if we're working out in this way, we're talking time and probably forgetting any consequence of going forward with these charges. And then finally, with my old hat as from within justice, this will, whatever they do, right away go on the sort of DOJ wish list next time there's crime legislation to try to clean it up and restore. But you're right, the havoc it could wreak on, what still is the biggest and in some ways most important, prosecution. If you collect it all, the marauders themselves would be, untold. And then, of course, Trump. So we will be already having bated breath at the end of May and in June waiting for the immunity opinion. Now we'll have another one to be waiting for. And when we first hear Fischer intoned, we'll be listening very closely. Thank you very much, Mark, for being with us and kind of laying out the stakes here, which are pretty damn big, it seems to me, and I think you agree. So, one of the other, there seemed to be a lot that's star-crossed about the different efforts to bring a trial and accountability before the election, and here's one more.
Absolutely. Thank you so much for having me on the show, Harry.
Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.